That's me. I introduced myself. We're going to try and do it without a head mic. So today we're going to tell my favorite story of my favorite trial. And I hope I can make it yours. But on advice of legal counsel, I've been told not to go in the weeds. That makes it a little difficult. Okay, so we start. Again, you've seen this in the very first lecture where I introduced things. This is George Washington's lands as of 1786, which is when he tried this land case. And if you follow my, you'll see right there is Miller's Run, which is in southwestern Pennsylvania. And that's going to be the impacted property, which is a new acquisition for him in terms of asserting his legal title. But he's been trying to get a hold of this land from 1763. Okay, so that's a 13-year hiatus before he sues for legal title. And we'll look at what he's done in the interim to try to claim it. Okay, next file. So while we're waiting for the next slide, no? Yes, okay. This is a survey that was written up by William Crawford, who was a member of Washington's regiment in the French and Indian War, and was also his land agent, and was himself an Indian fighter. But this is what a proper survey looks like, and it does happen to be for one of Washington's lands, along with some other claims mixed in. It shows you what it should look like. And this one is from 1771, so it's going to be from the same period as the next slide that I'm going to show you, which is going to be the slide for this preferred piece of land that Washington is dead set on getting a hold of. And you can see it's barely visible, and I've had it computer enhanced. It's called Faint Guess, in quotes, which is the way that Crawford referred to it in a letter to Washington. But what he wanted to do was to identify it. No, all right, so the property's supposed to be up in this area. And now I'm having a hard time locating it, but I think, oh, go back. Okay. In any case, this one is from, this one has annotations in Washington's handwriting, so we know that it passed from Crawford to him. And it's supposed to be down here, which should be up here, in this circle here, is this land he's referring to. And the reason he put together this map is to distinguish Washington's property from a counterclaim against the same property. And he refers to it in his letter as 2 miles from the utmost limits of the land of George Croghan on Miller's Run. So Miller's Run is the name of the property. This has also been referred to by Hulbert, who writes on law in this period, from this period, he is of this period, has been referred to as the best example of a tomahawk claim. So even as Washington is trying to gain legal title, he's still using the appurtenances that settlers used to identify their land, which by making tomahawk marks on trees and then measuring them by poles and chains. He's going to have this land any way he can get it. And the only reason we have this map, even in this condition, is because of his notoriety and the fact that they were already aware in 1771 of how important a figure he was, if only because of his rescue of General Braddock's troops during the French and Indian War. But by 1781, which is going to be just as he's considering mounting this suit, he will have Washington County, Pennsylvania, named after him for his exploits in the Revolutionary War. Can you imagine being a group of settlers, seceders settlers? They're seceders from the Scottish Presbyterian Church who settled on what he claimed was his land. They have to go up against him, having the county in which this land is situated named for him just 3 years before the suit is going to go forward. So it's going to be a little bit of an uneven terrain here. Okay, we can go to the next one. What I'm trying to do here is to start identifying important documents for you. You won't have to read them. But this should be, let me see. I wish I could see it. What I want to show you is, this is the actual patent that he filed for, which was in contention all the way from the time he claimed that a survey had been made on that land, which was in 1770. Then he changed the date to 71, then he changed it to 1773. So he kept claiming all along different dates in his legal brief that he wrote for this case, and also in his letters to his lawyer and to his legal advisors from both Virginia and Pennsylvania, which made him a very suspect client, right? In any case, his claim was that if you look at this patent, which he finally got in 1774, which was already well after these settlers had settled on his land, so can you really claim this land on the basis of a document that comes after the fact? This patent for this land, legal written title, comes after the fact of settlers having settled, and by virtue of improvements that they made on the land, and having lived on the land for 1 year, and having raised a crop of corn, which was the legal requirement from the 1779 Act for adjusting claims between Pennsylvania and Virginia. The land switched from Virginia to Pennsylvania. They had already met their legal requirement, but he was going to claim that because the government of Virginia gave him this land, which was subsequently transferred to Pennsylvania, that Pennsylvania was obliged to honor that agreement, or else it was a claim, or else he would make a claim of maladministration or land office corruption. With his name, that meant something, and he put that in his legal brief as well. But all you have in this document, there are no dates in this document to say what date it was that he did his survey, what date it was that he got the warrant, which would give him the right to make a survey, what date it was that he got the bond from the military officer in his regiment who he got to sell him his military bounty land for this purchase, what date that was. His claim was that all those dates would be in there. He was a surveyor. You saw the survey that Crawford put forward for him. It's exactly the same as what's information is in this patent. The lengths, the tomahawk marks, the pole measures, the chain measures, and then separately that this was by the proclamation of 1763, or 1763, right? And it was claimed on that basis. And then the amount of acreage. So this is going to be another strike against his claim for this land. Okay, we can go to the next one now. So that's a critical document, and this is a critical document, and this is the one that I explained to you in the very first talk that I had to spend a great deal of time to discover, to uncover, and we only found this page. This is his legal brief, the only legal brief he was ever known to have written. The claim is that we should not have to take his expertise as of any value because he wasn't a lawyer. Let me tell you about George Washington's experience. He was a member of the Virginia House of Burgesses for 6 years. He was a justice of the peace for 6 years. He was a justice of the County Court of Virginia. County courts in the colonial period did the bulk of legal work in the colonies. So he admitted members to the bar, he arbitrated cases, he did civil, criminal, and chancery cases. Chancery cases are the cases that go back to England because remember, England is in control of these colonies. He did as much work in the law as anybody who studied for the law as an apprentice or who read for the law in that time period. So it's not well known. And this would be the first case that will be published that will make the point that he was not to be taken lightly. As you can see, but you can't read, it says grounds, and it says, I think it says answers, but I can't see. In any case, he has, this manuscript includes 13 pages, 8 of which are his defense, 5 of which are the pleas that will be entered, that he anticipates will be entered by the settlers against his defense. And those would be in that column, the left column. To the right would be his responses. So as he establishes his grounds for his case, he will answer in this column what they would engage would be would undermine those issues. So there are 13 issues that he raises for himself. There are 9 that he will raise in this column that they will raise, and then he will answer their claims 9 times. It's a pretty well-written brief, as briefs went in this time period. In fact, it might even been better than most of what was out there. So that's one thing we need to know. If you go to the next page, and this is the last slide. This is just my working notes in progress, and I recreated his brief here in my abbreviations and the answers in this column. And then I made notes for myself on history and other things that I needed to know about. But so I have 15 pages matching his brief, which represents my work on his brief and my attempts to create a matrix out of it. So this was an early version of that matrix, just to give you an idea of how the work was, what was happening in terms of me working the document. Okay, you can close that off now. I think they're still busy. Okay, and we're skipping all those are not necessary. Okay, so we're at the point where we want to see how was Washington positioned in relation to this case. Well, he had this overweening fascination with the West. Remember, he was a surveyor, and he surveyed in Western Virginia, which was then to become Western Pennsylvania, from the 1750s. He served in the French and Indian War up through 1763. He was a recipient of a military land bounty at that point. He went on to inform Virginia's secession of land to the national government in 1780 in order to resolve colonial claims and state claims that were in conflict. That was an act of patriotism. He had a vision of an east-west waterway that ran from the Potomac River to Lake Erie, which was very visionary at the time, and for which they wished to honor him with shares in a land company, which he turned down because he thought that it would undermine his reputation to receive, as he referred to, as an emolument for his service. So he denied that. And then he became a land speculator for 30 years. So he became the second largest landowner in America, kind of self-interested. When it came time for the settlers in Pennsylvania to revolt against the national government in the first, which is the next case, the first treasonous rebellion in the new United States, he actually had considerable interests in the West. And as a result, when he led American troops and invaded the West to quell the rebellion, there was a considerable outcry, so that there was a protest that followed the troops and anticipated the troops with liberty poles and flags and symbols and protests all across the state of Pennsylvania. So it's an unresolved question. Thomas Slaughter, who's written a lot about the Whiskey Rebellion, is really rabid on the issue of this being a private interest invasion on Washington's part. But there are those who would defend him. Elkins, for example, who's written a massive history on federalism, takes a different point of view. A third point of view is taken by Joseph Ellis. Some of you might have read his book called Founding Brothers, which is a popularized version of the kind of history he does. He's a good historian. That was a little more popular than he usually does. He makes the point that Washington had a patriarchal problem, and that goes to the fact that he accepted the title of Excellency as Commander-in-Chief during the Revolution, and that gave him the status of pseudo-royalty. That followed him to the point where Madison made a comment about him. Let's see if I can find it. Which was later repeated by Jefferson during the rebellion, in which they claimed that naked he would have been honored as a sovereign, but he was carrying the rags of royalty on his body because he accepted this title of Excellency. So it didn't do him much good. All right. So we come to something that I want to do just quickly, because this is supposed to represent these talks, that these trials are tests of democracy. They're stress tests. So we should just very quickly see where we're at on that. And if you remember my first talk, I said there were 8 variables that are used by historians to test whether democracy has become dysfunctional over time, and they start with the 1790s. So where are we at? Well, we're hitting, with this case, 4 of the 8 variables. So conflict over economic resources, yes, this case demonstrates that. The rule of law, undermining the rule of law. The rule of law is a mess at this time and in this case. Inequality, we're here with inequality grossly. The settlers were impoverished, the immigrants were impoverished, the struggle for land was ugly, and Eastern speculators will do anything under the law to win their cases against these poor homesteaders. Racial tension with the Indians, big time. And until 1795, when General Wayne mounted a federal army, he mounted it in combination, more or less, with the army that was led against the settlers, and then Wayne took the next year a federal army against the Indians, and that settled Pennsylvania up to the Ohio Valley. So yes, racial tension with the Indians would be the last one of those. So as you can see, 4 out of 8, where this new democracy, which is considered an experiment, is not doing terribly well. Okay. So what are the conditions here under which this case is going to be tried? Well, Washington is going to represent a class of men who were despised in the West. And he fell into that category. Keep in mind, as I said, in 1981, when Washington County was named after him, he was also revered. So he's in a kind of a bind, double bind, catch-22. He is both despised and revered. But insofar as he was despised, why was he? Well, because he came from the East, because he was one of the founding elite, because he was a land speculator, and because his public decisions were influenced by private interests. He came to the West to visit his property in 1770 with William Crawford, his agent, at a time when the country was just beginning to bind together against the English. And one of the reasons was that the English had, in 1763, put up a boundary line by royal declaration that prevented Americans from inhabiting Indian lands from the Alleghenies on. And that so incensed the plantation owners in Virginia, of whom Washington was one, that they determined, it was one of the factors, one of the major factors that determined that they wanted to revolt against the British. So him visiting his lands at this time, you can put that in that context. When he came back in 1984 to file this eviction suit against the settlers, sorry, 1780. You're listening. The commonality that had been generated among the colonies had begun to dissolve because they were in a common cause against an external enemy. But having won the revolution, 1783 with the Treaty of Paris, they lost that bound-binding factor. So the West, beckoning as the place where the nation can expand and we can have a national binding together, was very prominent, right? And since states like Virginia gave over some of its land to congressional oversight to prevent conflicts between states, that gave them another leg up. Unfortunately, this desire for land was a source of corruption. In fact, land itself had become a fungible form of corruptible currency, right? And it was the only way that a lot of people who were disenfranchised had their chance, right? And we're talking about immigrants, we're talking about fugitive slaves. There's a fugitive slave population involved here too. And it's also a national goal, a means of fulfilling national aspirations, this business of the territorial imperative to move west and create an American empire. It's a source of wars because the French and the British fought wars, and the colonies fought wars, and then the U.S. fought the war against Britain, a lot of people will argue, because of their desire for land. So land was a big deal, and this particular frontier in Pennsylvania was a really big deal. Remember that soldiers who had gotten military bounties for fighting in the French and Indian and the American Revolutionary Wars were out there in force trying to claim their land, and that land was being bought up from under them, pennies on the dollar, by Eastern land speculators, of whom Washington was one. So as it turns, bottom line, what we have here is a struggle between people who are willing to settle on the land, work it, live off of it, improve it, and stay there. And as I said, the standard was produce a corn crop and live for a year on the land. Now, at one point when Washington figures that he's at risk for losing his land case, he will make a claim on the same basis, but he never lived there. He sent agents to live there. And there was a law in 1785 that anybody who had been forced from the land by anything other than judicial force had a claim on that land. So his claim was that the interloping settlers had forced him from the land, but also that his agents had been moving toward the land to make his claim when they were prevented from arriving there by Indians. I think that was a bit of a crock, and not only because he made so many unsustainable claims and produced unavailable witnesses. His witnesses were either dead or didn't have a memory or weren't really in the place where they were supposed to be in order to provide that kind of testimony. I mean, we're talking about 19 witnesses, only 8 of whom wind up on the appearance docket for the trial itself, and none of whom was his lawyer willing to call to testify because their testimony was so suspect. Okay. The legal situation at the time that this case is going to be filed. Legally, we have a situation where, for the first time, judicial review is coming into play. That means that courts are now determining whether or not the laws that legislatures pass are in fact legal. So this is the first time this conflict is coming into play. Legislatures are feeling very much under the gun as a result. They are siding with settlers because they want the land to be settled, worked, and lived on, whereas Eastern speculators merely coming there to take a profit from the land. The people in the East were defending Eastern speculators because they were investing in the new economy. And so the courts favored Eastern speculators. The executives of state and federal government are favoring Eastern speculators, but the legislature and local justices of the peace and county courts are supporting settlers, as well as common customs and usage, which is a form of American common law, which is different from English common law. It's a new innovation, and it's getting some respect as well. So Washington looked very good in terms of his reputation and his patriarchal standing, but the settlers had their supporters as well. And if it had been left to the county court, maybe they could have won. But the very first strategy that his lawyer, Thomas Smith, who was later to go on and become a Pennsylvania Supreme Court justice, he was very cozy with the justices through this whole process. He chased them from town to town, all through the Western Circuit. The Supreme Courts, both federal and state, had to ride the circuit, which they hated. And he made good friends with them, and his cases were based on what their predispositions were. And because the Pennsylvania Supreme Court took cases not on a legal but on a political basis, he got Washington's case removed from the county court, which would have been favorable to the settlers, and had it tried by Chief Justice Thomas McKean's Supreme Court. And I say it was his court because from 1774 to 1799, McKean was Chief Justice, and he ran that court. In 1799, did I say 79? In 1799, he became governor of Pennsylvania. So he was a very powerful figure. And he had a good relationship with Thomas Smith, even to the point where Smith went to him and said, you know, I'm interested in seeing this issue of the